All right, so Article 3. Where did I put the book? I may do this out of order because a lot of it I have memorized already, I think. So I'm going to do the stuff that I need to still memorize. Actually, maybe I'll just do the whole fucking thing. Yeah, I'm going to do the whole thing. Cplr 301. Personal jurisdiction by acts of non-domiciliaries. Acts which are the basis of jurisdiction. As to a cause of action arising from any act enumerated in this section, a court in New York can exercise personal jurisdiction over any non-domiciliary if he, in person or through an agent, 1. transacts or contracts anywhere to supply goods or services within the state, or 2. commits a tort within the state except for defamation of character, or 3. commits a tort without the state except for defamation of character causing injury to a person within the state, or if he regularly does business or solicits business or engages in any persistent course of conduct to supply goods or services within the state, or derives substantial revenue from goods used or services rendered within the state, or he commits tort without the state, and he reasonably should expect reasonably expects the act to have consequences within the state, except for defamation of character, and derives substantial revenue from interstate or international commerce, or owns, uses, or possesses any real property situated within the state. A court in a matrimonial or a family court action can exercise personal jurisdiction over a non-resident defendant or respondent if there is an action for support, alimony, maintenance, distributive awards, or special relief in matrimonial actions, if the party that's making the demand for the support is a resident of the state or domiciled in the state at the time the demand is made, provided that this state was the matrimonial domicile of the parties before their separation, or the defendant abandoned the plaintiff in this state, or the claim for support was executed under the laws of the state or an agreement in the state. The family court can exercise the jurisdiction pursuant to the Family Court Act and DRL. When personal jurisdiction is based solely upon this section, an appearance does not confer jurisdiction upon the defendant or respondent with respect to causes of action not arising from an act enumerated in this section. So I think what that means anyway, is that if you have to come to New York because you're being sued for support or maintenance, then you, just because you showed up in New York for that case doesn't mean that you can get sued for like breach of contract or something. D. Foreign defamation judgments. The courts of this state shall have jurisdiction over any person who obtains a foreign defamation judgment outside the United States against a resident of this state, or is a person or entity amenable to jurisdiction in New York who has assets in New York, which may be used for the satisfaction of the judgment, or may have to take actions in New York to comply with the judgment, for the purposes of rendering declaratory relief with respect to the person's liability for the judgment, and the purpose of determining whether the judgment should be deemed non-recognizable, provided 1. publication at issue was published in New York, and 2. resident or person amenable to jurisdiction has assets in New York which may be used to satisfy the foreign judgment, or may have to take actions in New York to comply with the foreign defamation judgment. The provisions of this subdivision shall apply to persons who obtain judgments in defamation proceedings outside the U.S. prior to and or after the effective date of this subdivision. This was added in 2008 to protect journalists and the press. Glad that they're so worried about that. 303. Designation of attorney as agent for service. During the pendency of an action, if you are not subject to personal jurisdiction but you come to New York and sue someone, they can sue you back. If you sue someone in New York, you could be sued. 304. Method of commencing action or special proceeding. An action is commenced by filing a summons and complaint, a summons with notice, or court finds that circumstances prevent immediate filing, the signing of an order requiring subsequent filing at a specific time and date, not more than 5 days thereafter, shall commence the action. A special proceeding is commenced by filing a petition, period. For the purpose of this section, filing shall mean the delivery of the summons with notice, summons and complaint, or the petition to the clerk of the court in the county where the action or special proceeding is brought, or any other person designated by the clerk for that purpose. At the time of filing, the filed papers shall be date stamped by the clerk who shall file them and maintain a record of the date of filing and shall forthwith return a date stamped copy together with the index number to the filing party, except when filings by electronic means. Such filing shall not be accepted unless you pay the fee. Where filing is by electronic means, any fee required shall be paid in the time and manner authorized by the fucking chief administrator. D. When filing is by fax, the clerk need only return a date stamped copy of the first page of the papers initiating the lawsuit together with the index number. E. Where filing is by electronic means, the clerk shall, in accordance with the rules promulgated by the fucking chief administrator, forthwith notify the filing party of the index number and the date and time of filing. So when it's electronic means, you have to notify the date and time of filing. F. A confirmation record produced by the filing party's fax machine or computer and an affidavit shall be prima facie evidence that the filing party transmitted the documents consistent with the date, time, and place appearing on the confirmation record. 305. Supplemental summons and amendment. A. A summons shall specify the basis of the venue and if based upon the plaintiff's address shall also specify the plaintiff's address and shall bear the index number assigned and the date of filing. A third-party summons shall also specify the date of the third-party summons being filed with the clerk. The summons in a consumer credit transaction shall prominently display at the top of the summons the words consumer credit transaction. And where purchaser, borrower, or debtor is a defendant, shall specify the county of residence of a defendant if one resides within the state, and the county where the transaction took place if within the state. When by order of the court or stipulation of all parties, or as of right pursuant to 1003, a new party is joined in the action, and the joinder is not made upon the new party's motion, a supplemental summons specifying the pleading the new party must answer shall be filed with the court and served upon such party. B. Summons and notice. If the complaint is not served, the summons shall contain or have attached thereto a notice stating the nature of the action and the relief sought, and, except for medical malpractice, sum of money for which judgment may be taken in case of default. C. Amendment. At any time in its discretion, in the interest of justice, the court may allow any summons or proof of service to be amended if a substantial right of a party against whom the summons was issued is not prejudiced. 306. Proof of service. A. Generally, proof of service shall specify the paper served, the person who was served, the date, time, address, or in the event there is no address, the place and manner of service, and set forth facts showing that service was made by an authorized person in an authorized manner. B. Personal service. When service is made pursuant to this article by delivery of the summons to an individual, proof of service shall also include a description of the person to whom it was so delivered. C. Other service. When service is made pursuant to nail and mail, proof of service shall also specify the dates, addresses, and the times of attempted service pursuant to subs 1, 2, or 3 of such section. D. Form. Proof of service shall be in the form of a certificate if it's made by a sheriff or other officer, in the form of an affidavit if made by any other person, or in the form of a signed acknowledgement of receipt. E. Admission of service. A writing admitting service by the person to be served is adequate proof of service. 306-A. Index number in action or proceeding commenced in Supreme or County Court. Upon filing the summons and complaint, summons with notice, or petition, an index number shall be assigned by the county clerk and the fee required shall be paid. Upon the filing of a summons and complaint against a person not already a party, as permitted under all those sections, the fee is paid, but a new index number does not get assigned. This is kind of a weird one. B, if someone other than the plaintiff pays the index number fee, the clerk shall issue an order directing the plaintiff to pay such person the amount of the fee. If the fee is not paid within 30 days, such person may apply to the clerk for an order dismissing the action without prejudice. The reason this is so weird is because it's like talking about the county clerk actually issuing an order. Two orders, an order to pay, and then another order dismissing the action without prejudice. 306-B. That is the 120-day rule. You have to serve the person within 120 days, except a proceeding commenced under the election law. Election law, where the statute of limitations is 4 months or less, service shall be made not later than 15 days after the date the statute of limitations expires. If service is not made upon the defendant within a period provided by the section, the court, upon motion, shall dismiss the action without prejudice as to that defendant, or upon good cause shown or in the interest of justice, extend the time for service. 306-C. Notice of commencement of action by recipient of medical assistance. So if someone's receiving medical assistance and they're suing for personal injuries, who either them or whoever is suing on their behalf has to send a notice to either the local social services district in the county where the recipient lives, or they have to send it to the Department of Health by registered mail, return receipt requested, within 60 days after service is complete on all the other parties. Proof of service of the notice is filed with the court, and the sending of such notice shall not be a jurisdictional requirement to commencing the action.